Hello, my name is Claudia Lewis, and I'm a partner with the law firm Venable. We're located in Washington, D.C. I'm the co-chair of the FDA group, and I have been tasked today to give you some information on the adverse event reporting system. And the name of my presentation is called, Are Your Customer Complaints a Ticking Time Bomb? The new adverse event reporting requirements went into place at the end of 2007, and there's lots of rules and regulations that we need to be aware of, and I hope that by the end of this presentation that you will know how to be in compliance with them. We have a full agenda, so let's get started. I would like to start with just some general definitions. As I indicated, the rules went into effect in 2007. Actually December 27th, so they really went into effect in 2008. And it's the first time that the agency had mandatory adverse reporting for dietary supplements. So the definitions that we need to work with are adverse events and serious adverse events. And adverse events are any health-related events associated with the use of a dietary supplement that's considered adverse. So think if someone calls your company and says, I took your product, I got nauseated, or I had a headache, or my stomach hurt, or I had breathing problems, those would be considered adverse events that you have to now keep records of them. A serious adverse event, on the other hand, is one that is very serious, and there are several factors that you should evaluate to determine whether your event, a consumer's report, is a serious adverse event. And these factors are death, a life-threatening experience, inpatient hospitalization, a persistent or significant disability or incapacity, or a congenital birth defect, or it requires intervention based on sound medical judgment to prevent one of the outcomes described above. And it would seem that these different factors, since they've been outlined very clearly by the FDA, would be very easy to adhere to and make a determination as to whether you need to make a report to the FDA, but it's not as easy as it seems on face value. So let's delve a little bit deeper as to what each of these different serious adverse events really mean. Well, death probably is the easiest of the serious adverse events. And so the outcome of consuming the product would be death itself. Life-threatening is where we suspect that the consumer was at substantial risk of dying at the time of the adverse event, or the continued use of the device or other medical product might have resulted in the death of the patient. Hospitalization. Initial hospitalization or prolonged hospitalization means admission to the hospital itself, and the hospitalization was a result of the adverse event. The common question concerning hospitalization is whether my customer called and said they had to go to the ER. Well, simply going to the ER is not always a serious adverse event, so there's a little more investigation we have to do to determine whether a visit to the emergency room really constitutes a serious adverse event. So what we need to look at is whether one of the other serious outcomes, when we talked about needing to have treatment or intervention, whether someone had to have some type of intervention, or the damage was permanent or prolonged, would determine, or they had to actually be treated at the ER, would determine whether we should submit a serious adverse report to the FDA. So the other factors we want to look at is disability or permanent damage. If the adverse event resulted in a substantial disruption of a person's ability to conduct normal life, the person couldn't walk anymore, the person now has to be on a fibrillator or have some other type of regular intervention, then the agency would say, yes, that's a serious adverse event and it should be reported to the agency. If there's a suspicion that the product caused some type of birth defect or abnormality during conception or during the pregnancy, then that also needs to be submitted and reported to the agency. The last factor that we need to look at is whether there was a required intervention to prevent permanent damage or impairment. And so the agency rationale looks and evaluates whether a medical or surgical intervention was necessary to preclude permanent impairment of a body function or to prevent permanent damage to the body structure. And if that was the case, then a serious adverse event needs to be reported to the agency. And so the agency also has a safety net, if you will. So they talk about other serious or important medical events. And that is when a serious adverse event has to be reported to the agency where it doesn't fit into one of the other outcomes, but the event may jeopardize the patient and may require medical or surgery intervention to prevent one of the other outcomes. So some good examples so that you can have a baseline as to what you need to evaluate when these consumers call in with these products. If someone says, I have a serious problem breathing, or I had a serious blood disorder, or I now need to take a specific type of drug from now on, then the agency would consider that to be an other serious or medical event that would require submission to the agency of a serious adverse event report. So now that we have an understanding of what the adverse events are versus serious adverse events, what do we do with this information? The regulations that were implemented in 2007 require that we now keep records of all adverse events, whether they're serious or not. And we have to keep those records for 6 years from the date of receipt of the report. In addition to the record-keeping requirements, there's some labeling requirements. So we now must have our domestic street address or phone number where people may send reports of adverse events. So report to the FDA, and who must report to the FDA? So we have a serious adverse event. Someone was seriously sick and had to be hospitalized. We put this report together, we have it in our records, and now we're ready to send it to the agency. Who has the responsibility? Under the statute, the manufacturer, packer, or distributors whose name appears on the label must report to the FDA any serious adverse event. You have to submit the report and a copy of the label, and that all must be done within 15 days of receiving the report. And there's a couple of caveats to that. A distributor's whose name appears on the label may, by agreement, so you have a contract with your manufacturer, authorize the manufacturer to submit the report to the agency instead of submitting it itself. In my experience, it's best that if your name is on the label for you to submit your own serious adverse event so you can make sure that it's done properly and in a timely manner. The other thing that I would like to mention at this time is that from time to time after you've received a serious adverse event, a customer might call back with some additional information. I called you 6 months ago and said that I was taking an antibiotic after taking your product because I developed an infection. I'm calling you now to let you know that the doctor has released me from taking the antibiotic, or I'm calling to let you know that the doctor thinks that it wasn't related to your dietary supplement. So any new medical information you receive within 1 year of the original report must be submitted to the agency. So you can submit that information to the agency, and you must do so no later than 15 business days after the new information is received. Another factor that comes in from time to time is the GMP requirements. I often have clients who have customers who call in and said, my pill smelled funny, or the last time I received the product, the pill was green and now it's blue. And the bells should go off anytime that happens. And even though it's not an adverse event, no one is saying that they're sick, and no one's saying they had to go to the hospital or seek medical treatment. But there may be a GMP problem, and you should conduct an investigation. And so the question the agency would ask with that type of complaint would be whether there is a failure to comply with any GMP related requirements. Did they miss the specifications? The specifications haven't been met. I had a client where a consumer called in and said that they had a headache after taking the product, and they re-looked at the pills, and the pills were yellow when they typically were white. And it turned out that the manufacturer, unbeknownst to us, had mistakenly missupplied the product. So we ended up doing a recall after doing an investigation, and we didn't have to do a serious adverse report to the FDA, but we did have to make an adverse report in our records. It also alerted us to GMP problems. So there's a couple of different regulatory factors that, although the AER system seems daunting, can help us make sure that the products are safe and that we're getting the products we intend to the consumer as well. Here's some information, and I'm not sure how well this is going to translate and whether you can see this, but I wanted you to see what the form is that you would submit the serious adverse event to the FDA on. And it's called MedWatch Form 3500A, and you can find it online. And this is the form that all serious AERs have to be submitted to the agency on. And lots of the information you may not be able to get from the consumer because the consumer may be in panic when they called, or for other reasons you may not be able to get the information. But I want to alert you there are 5 data elements that you must, at a minimum, get from the consumer that must be a part of this MedWatch form that you submit to the FDA. So at a minimum, you must be able to identify the patient, so you must know your customer's name. You must have an identifiable piece of information from the individual who is reporting the health problem to the firm. Sometimes it's a husband and wife or aunt and uncle. You want their information. And you must have identity contact information for yourself, so you must be able to give the agency information on who you are and how they can contact you. We must also give the information on the suspect dietary supplement. And this is regardless of whether we feel that our dietary supplement is responsible for the SAER or not. We have to give that information to the agency. And we should give as much detail to the agency as we can about what the serious or fatal outcome was in connection with the event. And those 5 pieces of information should be given anytime there's a SAER. Now that we understand what adverse events are, what serious adverse events are comprised of, and when we should submit them to the FDA, how we submit them to the FDA, I thought it would be very interesting to give you some statistics on the number of adverse events the agency has received since the new rules have come into place. And as you will see as we go through these statistics, the dietary supplement industry remains very safe. There are not very many reports when you compare the number of dietary supplements that are sold across the United States and around the world. But the GAO, the Government Accountability Office, wanted to take a look to make sure our adverse event system, reporting system was functioning properly. Obviously, the FDA's goal and the government's goal to make sure that we have safe products in the marketplace. So here are some statistics that you might think are of interest. So from 2008 to 2011, the FDA received a total of 6,370 adverse event reports related to dietary supplements. And 71% came from or generated due to serious health problems. And most were linked with dietary supplements containing a combination of ingredients, both vitamins and minerals. I know that most people think that most of the serious adverse events are connected with botanicals, but vitamins and minerals have some of their own issues as well. And here are here's a graph just to show you with the most commonly reported types of supplements associated with adverse events. And so we have combination products, we have vitamins, we have minerals, we have fat and lipid substances. You know, think of your omega-3 fatty acids. Think of animal byproducts and extracts, protein or fiber. We have herbals and botanicals, which are the pretty small on the graph here. Since the agency has been evaluating adverse events under the mandatory system, they have received more than twice the amount from 2008 to 2011. For example, they received 1,119 in 2008, and that doubled to 2,400 roughly in 2011. And the GAO attributes the rise to the large increase in the number of mandatory industry AERs, because now that they're mandatory, they're now being submitted to the agency under the new rules. And again, the AERs almost tripled from 689 in 2008 to 2,040 in 2011. And the number of voluntary AERs have remained stable. So if people don't feel like they have a serious adverse event, they're not generally reporting it to the agency as a general proposition. And here's a graphic just to show you the increase of AERs as we've gone through the mandatory system, and people have ramped up to make sure they're getting into the agency consistently and in a timely manner. And so one of the questions that I thought about in terms of, what is, driving the increase in mandatory AERs, and two things readily come to mind that I think are important for you to know is that there's an increased enforcement efforts against AER noncompliance. I do inspections with companies every single day, and there's not a time of the agency that's coming in to do an inspection that they don't ask about adverse event reports. Is one of the first things the agency asks for and evaluates. And where there's noncompliance, there are certain enforcement action tools available for the agency, and I'll get to that in a minute. And then, of course, there's been lawsuits publicizing the consequences of adverse events and firms' decisions not to report serious adverse events. There have been a couple of instances where the firm didn't think there was a serious adverse event. The FDA disagreed, and that's been publicized. So I think that members of the industry have sort of taken note of that and decided not to have that bad publicity and submitted them to the agency as required. And so one of the things I wanted to look at to help my clients feel more comfortable with reporting serious adverse events to the agency was, what are the most common serious adverse events? You shouldn't feel alone that something has happened. But again, this industry is still very safe. And so we have 53% of the adverse events that are unspecified important medical events of a serious nature. 29% result in hospitalization. 20% result in serious illness or connected with serious illness and injury. 8% are life-threatening conditions, and only 2% are related to or have resulted in death. We've looked at lots of data, and we have looked at different data points, and we have statistics. So now the question, of course, is what does the agency do with this data? And so the Center for Adverse Event Reporting System staff reviews the AERs for accuracy and then distributes the subject matter to subject matter experts within CFSAN. And so if someone called in with heart palpitations or cardio type of events, it would go to a cardiologist within CFSAN. Those subject matter experts then review to determine the extent of the relationship between the product and the health problem. So they're evaluating to make sure there is a cause and effect. And then the data analysts use statistical tools to analyze relationships across all AERs to detect potential problems and indications of unsafe products. And here, where we are getting where AERs are coming in saying I had not, consistent cases of nausea or I had consistent cases of dizziness, the agency will evaluate to make sure that this is still a safe product or the ingredients are still safe so they can continue to be used as dietary supplements. In certain instances, the agency's investigation determines that the product contains an active drug or other FDA-approved drugs. And I had a client who had an instance of this where, unbeknownst to my client, the product had been spiked with a very well-known cholesterol-lowering drug. We did a recall and got the product out of the marketplace, but that's something that CFSAN would share with the Center for Drugs, and CEDAR would take over from there. And if there's an issue related to compliance with GMP regulations, as I mentioned earlier, the product had been improperly filled with the wrong dietary supplement, that type of information would be passed on to CFSAN's Office of Compliance, and the Office of Compliance would take over from that vantage point. And so what has FDA found in terms of its inspections and investigations of the cause and effect, or whether there is really a causal link between a dietary supplement and the adverse event? And the statistics reveal something very interesting. FDA was only able to establish a certain relationship between the supplement and a reported health problem in 3% of the AERs. So that's a very low statistic. For 67%, FDA could not determine whether the supplement caused a reported health problem because the AER contained insufficient information. So the agency is really looking to make sure that those 5 factors that we talked about a little bit earlier are really contained in the MedWatch form, and it's very important so that they can make sure that dietary supplements are safe. So now that we've had some statistics and gotten some information on what FDA does with this information, how important it is to the agency, let's look at the enforcement action side of things. And the agency has increased its number of inspections in connection with AERs. As I mentioned, that even when the agency is doing just a typical inspection of a firm, AERs is one of its #1 priorities. And so in 2008, FDA inspected 120 dietary supplement firms, which only represents about 6% of those companies that would be eligible for inspection under the dietary supplement rules. And from January to September 2012, by comparison, the FDA had already inspected 410 dietary supplement firms. So that was 18% of the total dietary supplement companies that were eligible for inspection. And so during those inspections, the FDA identified 20 problems. 3 firms did not submit a mandatory AER within 15 days, and 17 of the problems identified by the agency found that the firm did not submit the mandatory AER with sufficient information. So let's talk about what the agency is looking for when they're conducting these inspections. And so the agency, whenever an inspector goes out, gives them certain direction. And these directions can be found in the Instruction to Inspector Compliance Program Guidance Manual, and you can find exactly what the agency is looking for. And here are just a few highlights that I have for you. They want to make sure that the firm is aware that there's been a new law in place for adverse event reporting, and they want the inspectors to review up to 5 different dietary supplement label products to assure that the labels bear a domestic name or a domestic phone number so that consumers know where to call to submit these adverse event reports. They want to make sure that if the firm, this is not mandatory but is recommended by the FDA, if the firm has a prominent statement informing consumers that they may report serious adverse events to the domestic address or domestic phone number on the label, that the statement is made in a way that consumers can understand and that it's done in a way that the statute intends for it to accomplish its goal that consumers will actually submit adverse event reports. They also are looking to make sure the firm has a record-keeping system in place. As I mentioned, we're required to keep a record of adverse events, whether they're serious or non-serious, for a period of 6 years. And they want to make sure that you have a system in place. And we routinely recommend that you have a standard operating procedure for the record-keeping system and that people have been trained on it. And we determine if the firm has a process in place to report serious adverse events. As I mentioned, we have to report those adverse events on MedWatch Form 3500A. We want to make sure that whomever is submitting it knows how to submit it and make sure they know that the 5 pieces of information that has to be included on the report are included. And the agency is also looking to determine whether the firm has submitted any reports to the FDA since the rule became effective or since the previous inspection. And they want to make sure that they're being done in a timely manner. We mentioned we have a 15-day rule. And don't worry, if you have, after hearing this, you have a serious adverse event or you think you might have a serious adverse event, you know, the agency will take it late. It's better late than never. And so the agency is also making sure that they will evaluate your non-serious adverse events to be sure that there are none that would be considered serious by the agency but have not been submitted to the FDA. I'm sure we're all familiar with, there was a homeopathic product that you stuck in your nose and it was for cold and flu season and it was causing a loss of sense of smell and a sense of taste. Now most of us wouldn't consider that a serious adverse event because it was very transient and people, the normal sense of smell and taste would return. But the agency found that that was a serious adverse event and it should have been reported to the agency. So sometimes we'll have what we consider to be non-serious reports in our records and the agency will say, no, we consider that serious enough that a SAER should be submitted and you will submit the MedWatch form at that time. And so if the agency does find violations of the record keeping and reporting requirements, there are certain steps that the inspectors are required to take. If the FDA finds that the firm has failed to perform any or all of the reporting requirements, then the district would submit a warning letter to the CFSAN that this particular firm should receive a warning letter. If the firm has performed all the requirements but the documentation or the actions appear inadequate, your SOPs are not up to date, people haven't been trained, there's been lots of transition, not all the information that is required is included, you may receive an untitled letter from the agency. And an untitled letter is just a step below a full warning letter, letting you know that you need to get these types of systems in place as soon as possible. And so failure, and I would say repeat failure to report serious AERs within 15 business days will likely result in a warning letter. The warning letter would outline exactly what the failures have been and will ask the company to inform the agency of what they intend to do to come into compliance. And typically when we receive these types of letters from the agency, if the SOPs are not in place, we get SOPs in place. If training is what the problem was, we get training in place and report that to the agency and put a compliance plan in place to let them know that the AER system is up and functioning, we've been training on it, and that this won't happen again. And usually the agency is satisfied with that type of approach and response. So we now understand that the agency will send warning letters or untitled letters, and the agency has done so. There's been examples where a company did not or failed to There's been examples where a company did not provide complete domestic address or domestic phone number on the product label so that a consumer could report an adverse event, and the agency sent a warning letter due to the lack of proper contact information on the product label itself. And the agency has been fairly consistent that the MedWatch number is inadequate. You have to provide your own number or your domestic address itself. The agency doesn't always stop at warning letters. Where there's serious problems, the agency can take and does take more serious action, enforcement action. And in 2011, the agency sought and received a permanent injunction against a dietary supplement company who was in serious violation of the GMP regulations. And they also were in serious violation of failing to submit serious adverse event reports to the agency. The company had received several serious adverse events, and none of them upon inspection had been submitted to the agency. And so the FDA sought permanent injunction, and so the company can no longer manufacture or distribute its products until it comes in compliance. And one note is that this is very serious, and I'm sure the agency went back and forth with the company before they took this action. And so there's a lot of steps you can do in between before you go from receiving a warning letter to a permanent injunction. It's not as much as it used to be, but the agency does go back and forth. So if you get into compliance, a permanent injunction would be the worst case scenario in most instances. And the other thing the agency has been looking at in terms of increased enforcement action on this side is at the point of import. And so when the company seeks to import a product from overseas, the agency has its best option to look at the label and review it in detail. And where the contact information is not there, the agency has denied import to the product until it can be reconditioned and the information that's required has been placed on the label. There are also consumer alerts. I'm sure you've seen Hydroxycut, where they've had some pretty serious adverse events. The company didn't believe that they all were serious adverse events. The agency disagreed. So they received 23 serious adverse event reports ranging from jaundice to elevated liver enzymes. And the company had submitted some, but not all. And there was one death reported due to liver failure. And so the agency requested a recall and just put everyone on alert that Hydroxycut could cause some serious events if not taken properly. And there was also a drug company, and the Supreme Court got involved, which was very interesting, where the Supreme Court ruled in favor of investors suing a publicly traded drug company, allowing shareholders to rely on the firm's decision not to report AERs on the grounds for a claim in their lawsuit. So the fact that the drug company didn't submit the adverse event reports to the agency allowed a securities fraud claim to go forward. So it's very serious, and there's lots of consequences that could fall outside FDA regulations to something much more serious. Securities fraud is pretty serious. So I think that the rule of thumb is to evaluate your adverse event reports, get a system in place, and make sure that we're following the rules as closely as we can. We all have heard about caffeine and the serious adverse events reports surrounding caffeine. There's been lots of news and movement on the Hill in terms of whether caffeine is a safe ingredient or not. And the FDA in 2012 announced that it's investigating the adverse events reports connected to energy drinks. And one of the complications surrounding this is that, some of the energy drinks are marketed as foods versus dietary supplements, and there are no mandatory adverse event requirements for foods at this time. And so here's a list of adverse event reports that is received in connection with caffeine, and I thought this would be helpful for you to evaluate whether you have any of these. And these are ones that the agency would consider reportable to the agency. Death, obviously, convulsions, heart rate, blood pressure, heart attack, dizziness, loss of consciousness, and severe vomiting are all what the agency would consider reportable events to the agency. Caffeine, it remains to be seen what happens. To date, the agency indicated that it is conducting an investigation, but so far no further action has been taken. And it goes back to what we talked about a little bit earlier, in that fact that it's very difficult for the FDA to fully evaluate whether a product caused an adverse event or simply coincided with it. And so the agency is keenly aware that the fact that a person took a dietary supplement does not necessarily mean that the dietary supplement caused the adverse event. So they take it very seriously in terms of their investigations and trying to make sure there is, in fact, a causal connection between the two. And I'm going to leave you with some best practices. I mean, we've talked about a lot of important information, and I want to leave you with some things to actually do and put in place, have a meeting about. These are things that I counsel my clients on every day. Have a script prepared for incoming calls. Customers are going to complain. Many customers feel that they have to have a complaint because they might not get a refund otherwise. So it's very important to have a script prepared to make sure that we're getting the required information and we can weed out a complaint for refund purposes, one that's actually an adverse event, and ones that are serious adverse events that we have to actually get into the hands of the FDA. Establish internal review protocols. The 15 business days seems like a long time, but it's not really a long time, especially when you may need to call the consumer back to make sure you have those 5 key pieces of data that the agency is looking for. Making sure you have your own kind of a statement that you want to submit to the agency along with a MedWatch Form 3500A. You need a hierarchy of decision makers. Does the president need to look at it? Does only quality control need to look at it? People are on vacation. People are all in the office. It's going to take time. So 15 days is not that much time. So it's best to be organized. And you should establish an internal record-keeping system. So where are we going to start? Where is it going to be maintained? Who's going to look at it? Who's going to sign off on it? Who's going to train people as we get new employees in to help us with this? I always recommend mock inspections and audits. I conduct them all the time. I come in, my clients don't know. Hello, this is the FDA. I'm here to conduct an inspection. And then we learn a lot from that to make sure that we're in line not only with the AERs, but the CGMPs and other things that are going on with the company. That is one of the best tools to let you know whether you're really ready for the FDA to come into your office or not. Evaluate your inventory. Make sure you have the label correctly labeled. Do you have your contact information on it? Do you have expected side effects labeled on the product? A lot of times, if you say you might get a headache, or this might happen when you take this product. People won't call, and it'll reduce the number of adverse event reports you have to take, because it can be burdensome on your internal system as well. Make sure you have an internal manufacturer report number so that you can follow the product, know what's going on. As we mentioned, there's GMP considerations going along with this. So when the product was improperly filled, we were able to track it very quickly. We didn't have to go through a number of systems trying to figure out which lot, which batch, which consumer received the product, or which to the extent that you're in retail outlets, which retailers received it. So if you have an internal manufacturer report, it's very helpful. And remember that we have to have a label submission. So when you do label runs, make sure you keep one in the file so that if we do have a serious adverse event, that we have a label ready to send to the agency, because again, 15 days is not that much time, and we don't want to spend time trying to get the original label or see if we can get a photocopy of the label so we can submit it to the agency in a timely manner. The other thing that I mentioned in brief, but I think is very important, because companies are very concerned about, if I submit this to the agency, I'm going to be on the agency's radar. Well, I can tell you that 9 times out of 10, I represent huge food companies, I represent huge dietary supplement companies, I represent small companies as well. There is not a company that doesn't get reports from the agency. I mean, you should see the recalls that go through my office. It was packaged improperly. It was with, peanuts were in the center when it shouldn't have been. The agency is used to receiving adverse events and mistakes happen within the company. Well, and they become suspicious is that you've been in business for 20 years and you've never had a problem. That's when it's a problem. What I usually recommend is that you do it in a timely manner. You submit the form as we're required, and you submit your own statement. And it's because the report, unfortunately or fortunately, is going to be a part of the public record, and you can say that you take safety very seriously, that you have quality control procedures in place, and that you don't believe that this adverse event was connected with the consumption of your dietary supplement, and that you've never had a report of this type of adverse event before. And so some of the things you should include in the statement should be the customer was taking many other medications. So you have to train your person who's taking the adverse event report to make sure they ask these types of questions. Customer had a pre-existing medical condition. We believe that there was an improper use of the product. And I can say that we want to include some of this information, but of course there's privacy considerations and things that you should talk with your counsel before you put all of that in your statement. But those are the types of questions that you should ask and include in your statement so that the FDA knows that we haven't had this type of problem before. This is an outlier, if you will. And you have the right to submit the report in anonymity. So you can make an anonymous report, and there's some requirements and some rules and regulations around that. And if you have any questions about that, you can contact me, because there's very discreet rules and regulations around supporting it or submitting it anonymously. And if you have any questions or need any additional information, I'm happy to talk to you or answer any questions. And I hope this was informative, and I hope this gives you an idea of how seriously the agency takes adverse event reporting, and it gives you some ideas of how you can be in compliance. Thank you for your time.